One of the first concepts that we explain to clients charged with a felony offense is the procedure known as a preliminary hearing in Pennsylvania. A preliminary hearing, what we explain to clients, is not a trial. Even though it looks like a trial, it sounds like a trial, it's not a trial. And we have to talk to a client about that, because oftentimes when a client enters a courtroom, the first thing they believe is that every appearance there is for the purposes of deciding whether or not they're guilty or innocent. The preliminary hearing is what is known as a prima facie determination. And what that means is that it's the government's opportunity to put on someone, usually in the form of the complaining witness or maybe a police officer, to testify as to what they observed or what they found. And what that will enable the judge to determine is whether or not they should hold the case for trial. In my opinion, an attorney should have three goals. The number one goal is getting charges dismissed, or prior to that, if you can manage it, having the prosecution withdraw the case. More than likely, that's not going to happen. So the primary goal, in my opinion, is to try to get charges dismissed. And the way you do that is you force the government to put on its witness, and through the attorney's cross-examination, your defense attorney's cross-examination, he is able to show the judge that the person who is being accused of this crime cannot be brought to trial because the prosecution has failed to meet the elements of the offense that the person is charged with. If you're not able to get charges dismissed, the secondary goal of a preliminary hearing is to get charges downgraded. Typically, at a preliminary hearing, we are talking about felony charges. So if we're not able to get those charges dismissed, that secondary goal would be to get felony charges downgraded to, say, misdemeanor charges, or in the cases of a graded felony, to get it moved down from, say, a first-degree felony to a second-degree felony or an ungraded felony. The final goal of a preliminary hearing, again, in my opinion, is to collect information. Some attorneys refer to it as a poor man's deposition. And really, what we're attempting to do is to set up our case for trial. We can use it to attack the complainant's credibility, or maybe another one of the prosecution. A preliminary hearing is a very important step in the criminal process. You shouldn't overlook it. You shouldn't approach it with a laid-back attitude. Many people may tell you that it's a formality, that your case is going to be held for trial. I go into all my cases with the goal of getting charges dismissed. And if I can't do that, I'm going to my secondary goal of getting charges downgraded. And if I can't do that, I'm going with my third goal of collecting information, because I know I'm going to trial and I'm getting ready then, as opposed to weeks later. So you can't underestimate the power of a preliminary hearing. It is very important. I recommend to all of my clients, all my prospective clients, that you meet with your attorney, you discuss with him or her the charges, you let him or her know your story, because again, that story oftentimes forms the basis of your defense.